A week ago yesterday, on Monday, June 30th, the Supreme Court ruled 5-4 that the contraceptive mandate is applied to closely held corporations, violates a federal statute, the Religious Freedom Restoration Act. Justice Alito wrote the opinion for the court, joined by Chief Justice Roberts, Justice Scalia, Justice Kennedy, and Justice Thomas. Justice Ginsburg wrote the lead dissent. Justice Alito, writing for the court, said that corporations can claim to have religious free exercise. He said it's especially true as here, where it was a family-held business, what's technically called a closed corporation. He said requiring that such a business provide insurance coverage that includes contraceptives that violate its religion is a substantial burden of its religious beliefs. He said the court would accept that there's a compelling government interest in making contraceptives available for women, but he said there's less restrictive alternatives available. The government could directly provide contraceptives to women. The government could follow the same thing for these companies that it does for nonprofits, allowing them to opt out, but requiring the insurance company to cover, still to provide contraceptive coverage. Justice Ginsburg wrote a strong dissent, disagreeing with each aspect of Justice Alito's majority opinion. She disagreed that the Religious Freedom Restoration Act provides protection for for-profit companies. She disagreed that insurance coverage is a substantial burdening of religion. She disagreed that there's less restrictive alternatives. I think that though the case seems narrow, it is quite broad in its implications, and it's going to lead to an enormous amount of litigation. This is the first time that the Supreme Court has ever said that for-profit companies can claim to have religious beliefs and exercise religious freedom. I know if I want to run a business, I can do so according to my religious dictates, so long as I don't violate any other law. I create a corporation to have a separate entity to protect myself from liability. If there's a corporation, I'm liable only for what I invest in it. A corporation is a fictional entity. This is the first time the court has ever said that a for-profit fictional entity can have religious beliefs. The holding in this case is limited to family-held, close corporations, but the reasoning would seem to apply to all corporations. This is the first time the Supreme Court has ever said that free exercise is violated by not for what you force a person to do, but how the person is facilitating what others do. No one, of course, by this law is required to use or prohibited from using contraceptives. Hobby Lobby could still speak out against contraceptives. All Hobby Lobby is doing is providing insurance. If this violates the Religious Freedom Restoration Act, why couldn't a business that's owned by Christian Scientists say, providing any health insurance violates our religion? In fact, why couldn't Hobby Lobby say that we shouldn't have to provide salary that's used for contraceptives for abortions, and then enforce that? Or why couldn't a Jewish or a Muslim business owner say, none of our salary can be used to buy pork products? Where does it stop once the court has said this? And I think what this case is going to do is open the door to a tremendous amount of litigation as businesses are claiming that their free exercise of religion under the Religious Freedom Restoration Act is violated by various federal laws.